Hello and welcome to It's Time to Act, DOL's new rule expanding overtime eligibility, presented by Schiff Hardin. We are pleased that you've decided to join us for this important topic. A copy of the presentation can be found in the Handouts section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. Our speaker will answer questions via email after the conclusion of the presentation. I would now like to introduce today's moderator, Tracy Wallace. Welcome, Tracy. The floor is yours.
Thank you. Hello, everyone. On May 18, 2016, the United States Department of Labor announced the publication of a final rule that substantially revises existing overtime regulations, including raising the salary threshold for the first time in 12 years. Beginning on December 1, 2016, the Department of Labor estimates that over 4 million more Americans will qualify for overtime pay. The new regulations have sparked broad discussion about the potential impact. Leading our discussion today will be my partner, Will Carroll, out of Schiff Hardin's San Francisco office. Will has concentrated in labor and employment law for over 30 years, representing employers in trial and appellate courts and before a wide range of state and federal agencies. His practice encompasses all aspects of employment law, including litigating numerous wage and hour collective and class actions. He is a frequent speaker and a prolific writer. He is also a contributor to the Schiff Hardin Labor and Employment Law blog, which you can find on the Schiff Hardin website. And now I will turn it over to my partner, Will Carroll.
Thanks very much, Tracy. Well, welcome, everyone. I am very pleased to have the opportunity to present today's webinar on the Department of Labor's new rule addressing overtime eligibility. There's been a tremendous amount of press regarding the new rule and the changes it'll engender in the workplace. After months of speculation and literally tens of thousands of public comments on the proposed rule, the final rule has finally been released, and the clock for the December 1 compliance deadline is ticking. We'll hear that reference to that date a number of times in today's presentation. So I'd like to spend a couple minutes talking about what we'll be going over today in our webinar. First, we'll go over some of the basics of the current rules regarding what is known as the white-collar exemptions to the overtime requirements of the Fair Labor Standards Act. And just to be clear, we're talking about the FLSA throughout our conversation today. In many, many states, there are separate regimes for wage and hour laws. We won't be addressing those state laws, with perhaps an exception for some time spent on California towards the end of the presentation. But the rules that we're discussing, the overtime rules and the exemptions, are under federal law, the federal statute, the FLSA. Once we go through the general rules, this will give us some context for discussing the specifics of the new final rule that has just been released by the DOL. What has changed and what hasn't changed. Then, lastly, we'll spend some time addressing strategies for employers to consider in implementing the new rule. Okay, again, to give us a little context regarding how the rule has taken shape, this slide summarizes the timeline regarding the DOL's actions. In March 2014, President Obama directed Secretary of Labor Thomas Perez to, quote, modernize and streamline, close quote, the DOL's white-collar exemption regulations. And that was a fairly broad charge. On July 6, 2015, the DOL published its Notice of Proposed Rulemaking in the Federal Register. The comment period for the proposed rule closed in September with no less than 293,370 comments received. As you can see, that reflects a high degree of public interest in what the DOL is doing and really the almost universal impact that these rules will have on employers throughout the country. Finally, after the comment period closed, on May 18, 2016, President Obama and Secretary Perez announced the publication of the DOL's final rule, which will automatically extend overtime pay protections by increasing the salary threshold to $47,476 per year. Now, that will impact over 4 million workers within the first year of implementation. So the timing of the release of the final rule has been seen by some as an effort to preempt a possible congressional effort to undo the regulation by means of a federal law known as the Congressional Review Act. Now, under that law, Congress may adopt a joint resolution disapproving certain major final agency rules, and this rule would qualify as a major agency rule. If the agency rule is released late in the legislative session, the next Congress would have a 60-day period to take action against it. So the timing here suggests that DOL was alert to this possibility and wanted to avoid having a new Congress and possibly a Republican president take action against the rule. So the last date here is our December 1st, 2016 date, and that is the date that the final rule takes effect. All right, so let's talk a bit about the three components to the white-collar exemptions, which apply for the most part across the board. The new rule focuses on updating the salary thresholds that apply to the various white-collar exemptions. Before drilling down on what those changes are, let's spend a few minutes discussing the other aspects of these exemptions. So we'll start at the 20,000-foot level here. There are three basic components for these white-collar exemptions, which are sometimes referred to as the EAP exemptions, and that's short for executive, administrative, and professional. The first is the duties test. Now, this component focuses on the actual duties, responsibilities, and activities of the job. In order to qualify for each of these exemptions, the employee's duties must meet the particular requirements of the exemption in question. Second, the employee must be paid, quote, on a salary basis, close quote. And we'll discuss a bit more exactly what that means. And then third, the employee's salary must meet the minimum threshold established by a regulation. This is the focus of the new rule, which raised the minimum threshold and in so doing made millions of workers ineligible for exempt status. Okay. So beginning with the duties test, it's fair to say that the duties test typically receives the most attention in addressing employee classifications. The DOL has published detailed regulations addressing each of the white-collar exemptions, which spell out the particular definitions and tests that must be used in determining whether the exemption applies. We'll summarize them briefly here. Note that there are detailed regulations that flesh out these definitions. And the DOL publishes various resources on its website to assist the public in understanding and applying the exemptions. So, briefly, beginning with the executive exemption. To qualify for the executive exemption, an employee must be paid on a salary basis, must meet the minimum salary threshold, and must have the primary duty of managing the enterprise or managing a customarily recognized department of the enterprise. Now, when I say primary duty, that means the main or most important duty that the employee performs. This is determined based on all the facts, considering the employee's job as a whole. Also, to qualify for the executive exemption, the employee must customarily and regularly direct the work of at least 2 other full-time employees, or their equivalent, and have the authority to hire or fire other employees. If the employee lacks the authority to hire or fire, she may still qualify for the exemption if the employee's suggestions and recommendations as to the hiring, firing, advancement, promotion, or other change of status are given particular weight. So that, in a nutshell, that's the executive exemption. The second exemption in the EAP lineup of white-collar exemptions is the administrative exemption. Now, to qualify for this exemption, an employee must be paid on a salary basis, must meet the minimum salary threshold, and have as a primary duty the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. In carrying out these duties, the employee must exercise discretion and independent judgment with regard to matters of significance. Now, what does directly related to management or general business operations mean? To meet this requirement, the employee must perform work that's related to assisting with the running or servicing of the business, as opposed to working on a production line or selling a product. This kind of administrative work includes work in such areas as tax, finance, accounting, insurance, quality control, human resources, or computer networking. In short, areas that support and service the business enterprise. Moving on to the professional exemption. To qualify for the professional exemption, this would include learned professionals, creative professionals, teachers, and employees practicing law or medicine. Under the final rule, exempt professional employees must meet the minimum threshold for compensation on a salary or fee basis and must have as a primary duty either the performance of work requiring knowledge of an advanced type in the field of science or learning customarily acquired by a prolonged course of specialized intellectual instruction, or have as a primary duty the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. Now that sounds a little stilted. These are terms that are included in the regulations and in the definitions, so I'm trying to be a little specific here. Note that the new salary thresholds will not have an impact on certain exempt professionals. That's because the salary threshold and salary basis requirements do not apply to teachers, lawyers, or doctors under federal law. And lastly, we have the exemption for computer-related occupations. Now, to qualify for this exemption, the employee must receive either a guaranteed salary or fee of $913 per week under the new rule, or an hourly rate of not less than $27.63 per hour. In addition, the employee must be employed as an analyst, computer programmer, software engineer, or other similarly skilled position, and the primary duty must be in design, development, creation, systems analysis, or other computer-related activities as further defined and described in the regulations. All right, so now that we've gone through in a very general way the duties tests, the good news is that the new rule does not implement any changes in these duties tests. So going back to the publication of the proposed rule, the DOL didn't specifically propose any changes to the duty test, but it left open the possibility that such changes might be included, and specifically flagged the possibility of changing the rules to align it with the so-called 50% plus rule that applies under state law here in California. Under the California rule, an employee must spend at least 50% of his or her work time engaged in exempt activities in order to qualify for exempt status. The federal rule is different. While the duties tests refer to the employee's primary duty, there is no quantitative test for meeting that requirement. So employers breathed a sigh of relief when the final DOL rule was published. The final rule does not impose California's 50% plus rule, nor does it enact any other changes to the white-collar duties tests. The DOL has indicated that its focus on changing the minimum salary threshold has the advantage of being straightforward and predictable. Employers can readily identify which employees earn below the required amount and are therefore not eligible for exempt status. This is in contrast to the duties tests, which frequently require interpretation and application to specific factual contexts. In declining to make any changes in the duties tests, the DOL opted for simplicity. Okay, a few more words about the salary basis test. We said earlier that the white-collar exemptions require that the employee be paid, quote, on a salary basis, close quote. Now, there are two aspects of the salary requirement. First, the salary basis test requires that exempt white-collar employees, other than teachers, doctors, and lawyers, regularly receive a predetermined salary on a weekly or less frequent basis. Now, the employee must receive his full salary for any week in which he performs work, without regard to the number of days or hours worked. That amount cannot be reduced due to variations in the quality or quantity of the work performed. However, the employee need not be paid for any work week in which no work is performed. If all those requirements are met, the employee is being paid on a salary basis and potentially qualifies for exempt status. Secondly, the salary that is being paid must meet the minimum threshold set by the regulations. This is the focus of the new DOL rule. By increasing the minimum salary threshold, the DOL has excluded millions of workers from eligibility for exempt status. Okay, the DOL last updated the salary threshold in 2004 when it set the threshold at $23,660 per year. The 2004 increase was itself a significant increase from the $8,060 per year threshold that had been in effect for the preceding 30 years. The 2004 threshold corresponded with the 20th percentile of full-time salary workers, the salary paid in the 20th percentile of full-time salaried workers. According to the DOL, the 2004 threshold provides overtime eligibility to just 7% of full-time salaried workers today based on their pay, compared with 62% of the workforce who were eligible for overtime in 1975. And also according to the DOL, under the 2004 salary threshold, a worker earning less than the poverty line for a family of 4 could qualify for exempt status if he worked in a job that met the duties test. DOL expressed concern that excluding such workers from overtime eligibility could place undue financial pressures on lower paid workers and their families. The new rule sets the threshold at the 40th percentile. Now, by 40th percentile, I mean that according to the Census Bureau and Bureau of Labor Statistics figures, 40% of full-time salaried workers in the lowest wage census region earn at or below that amount. In other words, in order to qualify for overtime, a worker must meet the duties test and must earn a salary that places her within the top 60% of wage earners in the specified census region. And the regulations specify that the relevant census region is the lowest paying census region in the country, which currently for the present iteration of the rule is the South. The DOL has justified its increase from the 20th percentile to the 40th percentile by noting that back in 2004, the duties test was shortened, resulting in more employees potentially qualifying for exempt status. Now, according to the DOL, this resulted in a mismatch between a low salary threshold and a shorter, less rigorous duties test. In DOL's view, this combination led to an undue expansion in the number of employees who were exempt from overtime requirements. The DOL views the new rule as correcting this mismatch by increasing the salary threshold while retaining the same, less rigorous duties test. Now, the rule is the rule, and it is about to go into effect later this year, but I do want to articulate a couple of the criticisms that have been leveled and distill some of the points that were raised in the public comment period just to give us some additional context. The DOL's view has been challenged, in a number of quarters. DOL has been criticized for improperly inflating the role of the salary threshold test. The critics maintain that in the past, the threshold served as a means of excluding the obviously non-exempt without any need to refer to the duties test. Under the new rule, the salary threshold instead serves as an automatic bar to millions of employees who otherwise perform the duties of exempt white-collar workers. The new rule has also been criticized for adopting a one-size-fits-all approach. The salary threshold applies uniformly across the country. These critics suggest that a better approach would have been to adopt a lower salary threshold for regions with a lower cost of living. The DOL considered and explicitly rejected this approach. A couple more words on the December 1 effective date. An upward salary adjustment to meet the new threshold of $47,476 per year must be in place before December 1 to ensure continued application of exempt status. Just note, December 1 is a Thursday, and for biweekly pay, employers will need to adjust the pay for the pay period that includes December 1, 2016. Okay, we all know it's common for salaried employees to receive additional compensation in the form of bonuses, incentive payments, commissions, and the like. One of the common questions raised during the comment period on the proposed rule was whether such additional payments could be included in determining whether the employee meets the required higher salary threshold. The DOL's response was to create a limited role for these payments. Under the new rule, employers may use qualifying bonus, incentive pay, or commissions to count for up to 10% of the salary threshold. Currently, the 10% amount would come to $4,748. In the past, no such credits for non-salary payments were permitted. Under the new rule, in order to qualify, the bonus, incentive pay, or commissions must be non-discretionary. Examples include bonuses for meeting set production goals, retention bonuses, or commission payments based on a fixed formula. Discretionary bonuses can't be included towards this 10% amount. So, where the decision to award the bonus and the payment is at the employer's sole discretion and not according to any pre-announced standards, they don't count. An example would be a year-end Christmas bonus. What if the employer assumes the employee will make enough in non-discretionary bonuses and commissions to qualify for exempt status, but the employee falls short? So the employer assumes that the employee would be making at least $5,000 in commission payments, but lo and behold, the employee doesn't make quite that amount in commissions and doesn't meet the salary threshold as a result. Well, DOL has taken that into consideration and the new rule allows the employer to make what is known as a catch-up payment. So if an employer doesn't earn enough in non-discretionary bonuses in a given quarter to retain their exempt status, the DOL permits a, quote, catch-up, close quote, payment at the end of the quarter. The employer has one pay period after the end of the quarter to make up for the shortfall. Any such catch-up payment will count only toward the prior quarter's salary amount and not towards the salary amount in the quarter in which it was paid. If the employer chooses not to make the catch-up payment, the employee would be entitled to overtime pay for any overtime hours worked during the quarter. That is, they would not be given exempt status for that quarter. All right, let's address the automatic update feature of the new DOL rule. Every year that a salary threshold remains unchanged, fewer workers remain overtime eligible as wages overall increase over time. The DOL seeks to avoid this by adopting an automatic updating of the salary threshold. So as we said earlier, the threshold was last updated in 2004, 12 years ago, and before that it had been many decades, or a number of decades, without any update. And that will no longer be the case under the new rule, which features this automatic increase every 3 years. The automatic increases are designed to prevent future erosion of overtime protections and ensure greater predictability. Employers will know when the salary updates will happen and how they will be calculated. And they'll be able to estimate the amount of the salary update and make plans accordingly. So under the new rule, the salary threshold updates will occur every 3 years commencing on January 1st, 2020. Each update will raise the standard threshold to the 40th percentile of full-time salaried workers in the lowest wage census region. So the formula will remain the same, but the adjustment will occur and will be aligned with whatever that 40%, whatever the amount of that 40th percentile is at the time in the lowest wage census region. At least 150 days before the effective date, the DOL will publish a notice in the Federal Register of the updated salary and the total annual compensation that will be required. A DOL estimates that the new threshold will be $51,168 in 2020. That's an estimate. That's about 7.7% increase over the next 3 years. A similar increase for 2023, the next 3-year period, would reach a salary threshold of $55,108 for the year. And a similar increase for the next 3-year period in 2026 would be almost $60,000 a year. That gives you a sense of the steadily increasing thresholds that we're going to be encountering under the new rule. For employees at the margin, exempt status will be a moving target. In order to maintain exempt status, pay increases will have to keep pace with the trends reflected in the DOL's salary data. Now, some critics have noted that these automatic increases are likely to result in some salary compression over time. That's because mandated salary increases that are given to keep pace with the threshold for exempt status will narrow the spread in pay between more senior and less senior employees, or between highly performing employees and those who are not performing at a high level. These critics note that the new threshold of $47,476 per year will put many qualified but less experienced professionals at the same pay level with others who have more extensive experience, particularly in the nonprofit sector. This poses the potential for disruption and decreased job satisfaction of the more experienced workers. Another exemption that we haven't discussed yet is the exemption that's available for highly compensated employees. This exemption was created in 2004. Basically, it furnished a form of safe harbor for employers to classify highly compensated employees as exempt by greatly simplifying the duties test for these highly compensated employees. This exemption is available only to employees who perform one or more of the exempt functions of an executive, administrative, or professional employee. For example, an employee who regularly supervises 2 or more employees but does not meet the other requirements of the executive exemption may still be exempt as long as he or she meets the salary threshold for the highly compensated employee. Under the new final rule, the new threshold for highly compensated employees is $134,004. And this new rule also takes effect on December 1st, 2016. There's also an automatic update feature for the new threshold for highly compensated employees. Like the minimum salary threshold for the other white-collar exemptions, the HCE threshold will increase every 3 years, beginning in January 1st, 2020. The threshold will be set at the 90th percentile of full-time salaried workers nationally. The DOL estimates that the new threshold will be $147,524 in the year 2020. Okay, what counts towards compensation in deciding whether an employee is making enough to qualify as a highly compensated employee for purposes of this exemption? In order to qualify, the highly compensated employee doesn't need to receive the entire threshold amount in the form of salary. As long as the employee meets the salary threshold applicable to the other white-collar exemptions, that's $47,476 per year, the employer can count other non-discretionary compensation, bonuses, commissions, incentive payments, in order to meet the HCE threshold. So, for example, if you're earning $50,000 in salary and an additional $90,000 in non-discretionary bonus or commission payments, you can qualify for the HCE exemption. And there's also a provision for a catch-up payment here as well. If an employee's total annual compensation falls short of the required threshold by the last pay period of the year, the employee may, during the last pay period or within a month after the end of the 1-year period, make a final payment sufficient to achieve the required level. And this can happen, for example, if the employee is expected to earn a certain amount in commissions but falls short of the amount that would trigger the HCE exemption. In those cases, the employer can make a single catch-up payment at year's end, which would allow the employee to maintain exempt status for the prior year. And I'm referring to this one-year period. It's not necessarily a calendar year. It can be a fiscal year or any other 52-week period. All right, so we're now moving into the area of discussing how employers can take into account these changes that we've just been discussing and the new salary thresholds that will be online within the next few months. Many employers have already engaged in the critical first step toward compliance with the new rule, which is identifying those employees that stand to lose exempt status if no action is taken prior to the December 1 deadline. For some fortunate employers, there may be no employees who fall into that category, although even these employers will have to continue to track ongoing compliance in light of the triennial adjustments to the salary thresholds. For most employers, there will be a number of employees, and in some cases, a large number of employees, who stand to lose exempt status if no action is taken on the salary front. For all such employees, the employer is called upon to make a deliberate decision whether to increase salaries in order to maintain exempt status or reclassify employees as non-exempt. Many affected employees work little or no overtime. For these employees, a reclassification to non-exempt status wouldn't result in any substantial increase in compensation costs. The DOL estimates that 60% of affected employees, that is, employees who would no longer qualify for the exempt status under the minimum salary threshold test, that 60% of those employees don't work overtime. The agency estimates that 4.2 million salaried workers who were previously exempt will fall below the required salary thresholds. 4.1 million of these workers will be reclassified by their employers as non-exempt employees and be eligible to receive overtime. Again, this is what DOL is projecting. So that leaves 100,000 of these workers who will receive a raise so their salary is above the new threshold. DOL estimates that the final rule will transfer income from employers to employees in the form of higher earnings of approximately $1.2 billion with a B per year over the first 10 years. In addressing the reclassification question, it'll be critical to come up with an accurate estimate of the number of regular and overtime hours worked by affected employees. And in addressing that, employers have to make sure to include any time spent working outside of normal work hours, such as checking email, taking work home, and the like. Questions that need to be addressed include, will you continue to allow employees to engage in such off-premises work if they are reclassified to non-exempt status? What measures will the employer take to constrain such off-premises activities once employees are reclassified as non-exempt? How will any such constraints impact the number of hours that the employee works? So again, the exercise is trying to predict the number of hours currently worked by a salaried exempt employee and making an additional taking into account how those hours may be reduced as a result of non-exempt status and perhaps a tighter imposing tighter restrictions on the activities and the work performed by these formerly exempt employees. So another aspect of the planning process is going to be to consider options for minimizing overtime hours if the employee is reclassified as non-exempt. And these could include shifting work responsibilities to other employees. Some employers may feel obliged to cut hours to existing employees and spread those hours out to a larger workforce, which would mean adding headcount. so as to ensure that any overtime hours are minimized. It also may entail a greater reliance on the use of part-time workers. Now, keep in mind in deciding whether to reclassify workers to non-exempt status, there are some considerations that go beyond the dollars and cents of payroll costs. Reclassification, followed by capping of hours for previously exempt employees, may limit opportunities for professional development and advancement. An employee whose hours are limited doesn't have the option to take on extra work in order to gain greater experience or pursue extra opportunities for career development. Some of you may have seen earlier this week, the New York Times ran an article exploring the impact of hours limitations on formerly exempt employees in the fashion and media industries. In those industries, it's commonplace for ambitious individuals to log long hours at low pay in the hope of advancing their careers. Limits on hours for newly reclassified employees could restrict career development and potentially extend the timeline towards advancement and promotion. This is one of the trade-offs between biting the bullet on higher salary payments or reclassifying to non-exempt status. Oops, let's go back on here. Okay, so I want to address a common misperception that non-exempt employees must be paid on an hourly basis. In fact, employers who wish to reclassify previously exempt salaried employees as non-exempt may continue to pay them on a salary basis. In fact, there are several ways to do this. There are several ways to pay salary and pay overtime to a non-exempt employee. Choosing the most suitable method will depend on the number of hours the employee typically works and how many of those hours are overtime hours. I'll describe three methods. The first method for paying salary to a non-exempt employee is the most straightforward, and this would apply where the employee typically works 40 hours a week, but sometimes is called upon to work overtime, typically unpredictable and fluctuating with work demands. Here, the employer simply pays a salary based on 40 hours of work per week. Those weeks where the employee works more than 40 hours, the employee would be paid overtime for the additional hours at the overtime premium rate of 1.5 times the regular rate. A second option is to pay a straight-time salary for more than 40 hours in a week to those employees who regularly work more than 40 hours, then pay overtime in addition to the salary. By using the salary to pay for more than 40 hours in a week, the employer can reduce the amount of overtime premium that must be paid. Now, under this method, the employer is only required to pay an additional half-time overtime premium, as opposed to 1.5 times, for overtime hours already included within the salary. For any overtime hours that are worked beyond those hours that are included in the salary, the 1.5 times premium payment would be required. And I just want to note a note of caution that this method may not be available under the laws of certain states, and that would include California. So to give you an example, an employee who earns a fixed salary of $44,200 per year, which is $850 per week, for a 50-hour work week. The regular rate is determined by dividing the weekly salary by the number of hours on which the salary is based, in this case, 50 hours. So the regular rate here would be $17 per hour, which is $850 divided by 50. In a normal 50-hour work week, the employer would pay the employee the additional half-time premium for the 10 hours of overtime, which is $850 an hour. If the employee happens to work more than 50 hours in a week, the employer would then pay overtime at the rate of 1.5 times for any of the hours beyond 50. So the third method I want to address is known as the fluctuating workweek method. And this is where employees have hours of work which fluctuate from week to week, And in this case, employers can pay a fixed salary that covers a fluctuating number of hours at straight time as long as certain conditions are met. So under this fluctuating work week method, the employee is paid a fixed salary that does not vary with the number of hours worked during the work week, excluding overtime premiums. Thus, the employee receives his or her full salary for a work week, even when the employee doesn't work the full week due to illness or other reasons. Because the weekly salary is intended to compensate for all hours worked in the week, regardless of the number, the regular rate can be calculated by dividing the amount of the weekly salary by the number of hours actually worked. For example, where the employee works 55 hours a week, the regular rate is determined by dividing the weekly salary by 55. The more hours worked, the lower the regular rate. Now, under this method, the employee receives the set weekly salary plus overtime calculated at 1/2 times the regular rate for hours worked in excess of 40 during the work week. The overtime premium is limited to 1/2 times the regular rate because the salary already compensates the employee at straight time for all hours worked, including any overtime hours. To qualify for this method, the employee's hours must fluctuate from week to week, and the employer and the employee must have a, quote, clear mutual understanding, close quote, that the salary covers all hours worked. So in planning for this transition, employers should consider each of these options and decide whether one of these three options is more economical than the other. The fluctuating workweek method, where the conditions exist, tends to be the most beneficial in holding down overtime costs. A few words about tracking employee hours. Exempt employees often enjoy a degree of flexibility in their work hours. They often have greater freedom, for example, to leave early to pick up a child from school. Employees who are reclassified, exempt employees who are reclassified to non-exempt status, will have to adjust to less flexibility and greater reporting obligations when it comes to work hours. Now, having said this, there's no requirement under federal law that employees punch in and punch out on a time clock. Rather, the employer's obligation is to keep an accurate record of the number of daily hours worked by the employee. And there are different ways to do this. An employer may allow an employee to just provide the total number of hours worked each day, including the number of overtime hours, by the end of each pay period. Or the time can be recorded on an exception basis. For employees who work a fixed schedule, the employer need not track the employee's exact hours worked each day. Rather, the employer and the employee can agree to a default schedule that reflects daily and weekly hours and indicate that the employee followed the agreed-upon schedule when that happens. When the employee deviates from that schedule, the employer is required to record the number of hours actually worked. This obligation to track time for non-exempt employees applies to all hours worked, and this includes such activities as travel time and training time, time spent outside of normal hours, engaged in email communications and phone calls, and other remote activities. Exempt status typically entails a degree of flexibility, allowing employees to have greater latitude in performing work outside of the office or after normal working hours. This flexibility often includes greater discretion to attend to family or other personal obligations where necessary. Many exempt employees view this flexibility as a perk and see any constraints as undermining their independence and autonomy. Formerly exempt employees may have difficulty in adjusting to the constraints imposed on non-exempt employees, whose remote work must be diligently tracked in order to avoid any off-the-clock work. So these changes could lead to morale issues, with some employees viewing reclassification as something akin to demotion. These issues need to be taken into account in the planning process and in your employee communications as you anticipate making this transition for at least some employees. Also, mobile devices and other technologies increasingly offer the means to track employee hours while allowing non-exempt employees to work remotely with more flexible hours. So the the diminution in autonomy or independence can be addressed to an extent by some of the technologies that are coming online. Employers should explore these and other means of preserving flexibility for newly reclassified, non-exempt employees in order to minimize any sense that their autonomy is being intruded upon. A few words about adjusting wages. We're now addressing a situation in which the employer is exploring alternatives to increasing a currently exempt employee who doesn't meet the minimum salary threshold, and the question is whether to bump that salary so that the threshold is met, or to realign the compensation and pay the employee any overtime that's required in his newly non-exempt status. So in addressing the reclassification decision, employers will want to get a read on how overtime eligibility is likely to impact compensation for employees who were previously classified as exempt. Employers can seek to adjust the amount of the employee's pay to reallocate it between regular wages and overtime so that the total amount paid to the employee remains largely the same. The effectiveness of this option will depend upon the regularity and consistency of overtime hours worked by the employee. Employers may not, of course, reduce an employee's hourly wage below the applicable minimum wage or continually adjust wages each work week in order to manipulate the regular rate. So let me give you an example. An employee has previously been treated as an exempt employee, earning a salary of $37,000 per year, which comes to about $712 per week. Assume the employee regularly works 45 hours a week. Rather than increase the employee's salary to the new threshold of $47,476 per year, the employer can reclassify the employee as non-exempt and adopt a compensation method that seeks to maintain the employee at the same level of compensation. Two options. One, you can pay the employee on an hourly basis, $15 an hour. That would come to the same $712 per week, assuming the employee works at 5 hours of overtime, which would be paid at $22.50 an hour. Or the employer could pay a salary of $600 a week for 40 hours and pay overtime at the 1.5 premium rate for 5 hours, which would again come to the $712 per week. So the point here is that in transitioning to non-exempt status, the employer, if the overtime is reasonably predictable, it's a relatively straightforward exercise to set the employee's pay at a rate that will maintain the compensation that they had been receiving as an exempt employee. Obviously, where overtime is less predictable, that can result in issues. If the employer sets the salary too low and the employee incurs as a result the employee experiences a reduction in compensation because the overtime hours aren't there, you're going to be looking at morale issues. Or if there's more overtime than has been anticipated, you're going to be looking at exceeding projected compensation costs. So the predictability is really the central issue here, and the greater predictability you've got in hours, the fewer problems there are going to be. So I want to say a few words about, I suppose one might view this as a bit of a silver lining. This question of having a proper classification for employees, be it exempt or non-exempt, is one which human resources professionals have been dealing with for a very long time. And I think it's fair to say that most employers here have what we sometimes call Wobbler classifications. That is, classifications that could go either way. Arguably, they meet the test for a executive exemption. There may be some gray areas. You might have an administrative employee where the exercise of independent judgment and discretion doesn't seem so pronounced, and it really could be viewed in one of two ways. Or you might have a situation in which case law and the regulatory authorities have changed over time so that classifications that were once sound may no longer be defensible. And so just to be clear, I'm talking about classifications that focus on the duties test, not the salary test. So in any workforce, there may be a number of situations in which there are employers looking at some higher risk classifications. And in addressing these, employers are often reluctant to reclassify such positions out of concern that the prior classification may be challenged. An exempt employee is suddenly reclassified as a non-exempt, wonders why that's the case, and there may be some sense that the prior classification was improper and there might be the makings of litigation. So with the new salary thresholds that are mandated by the Department of Labor, many positions that fall below the threshold